¿Buscando dinero extra? Invierte en...
¿Esperamos al señor Gary o vamos acomodándonos para el inicio? Hacemos ya la transición para iniciar en el Facebook Live también, María José.
Me parece que Herman está comunicándose con Gary.
Sí, por favor vean el chat de panelistas.
Perfecto, entonces vamos a cerrar un momento el micrófono por 1 minuto y te doy el cue, María José, para el inicio.
Buenos días. Buenos días, Aurelia. Good morning and welcome to all participants, legal practitioners, students, and professors that have joined us this morning, and very especially to all the deluxe speakers that we have for our panels of the day. It is a great honor for this faculty to listen to the arbitration authors and experts that we usually study. In our arbitration program, we regularly read books and papers by Mr. Bourne or Mrs. Jimenez, for example, and today we will be able to depart with them regarding the innovative trends in international arbitration, as well as presenting Mr. Bourne's latest book, International Arbitration and Forum Selection Agreements, Drafting and Enforcing. The legal profession today faces unforeseen questions, opportunities, and expansion of our practice areas. And in spite of what some analysts or critics might constrict arbitration to, it is also growing and facing its own challenges and possibilities, which range from the technical analysis of matters such as forum selection that Mr. Bourne has analyzed in his book, which we will be presenting in the first panel, to the interaction with branches that traditionally might have been seen as parallel arenas, such as human rights and environment, as we will see in our second panel. It will certainly be a morning of quite a lot of learning for all, and for this, we thank each of the speakers for their valuable time and efforts, as well as all partners who have participated in the organization of this event. We especially thank Wilmer Hale, DJ Arbitraje, Climate Change Council, Zuleta Abogados, CICA-AMCHAM, Arbitration, and very, very specially, Simple Legal Consulting and Herman Duarte, who is always leading the way into new manners of thinking, of practicing, and even of conducting webinars. So with no further preamble, welcome, enjoy yourselves, and I leave you with Aurelia Garrido from the ULACIT Board of Directors. Good morning, Aurelia.
Buenos días, María José. En nombre de la Universidad ULACIT, les doy la más cordial bienvenida a este evento sobre tendencias innovadoras en arbitraje internacional. ULACIT es reconocida como la mejor universidad privada de Costa Rica de acuerdo al QS World University Ranking por su capacidad de innovar, de formar profesionales altamente competentes y de articularse con las mejores mentes e instituciones del mundo. Hoy, gracias a la colaboración con Simple Legal, nos honra ser anfitriones de un espacio de intercambio profesional con expertos de Reino Unido, Estados Unidos, Suecia, Colombia, El Salvador y Costa Rica, sobre un tema fundamental en la era de globalización, como es el cambio climático y los derechos humanos. Dos de los desafíos más importantes para la humanidad, pues del medio ambiente depende nuestra capacidad de poder vivir en el planeta y de los derechos humanos depende que esta sea una convivencia pacífica y digna para todos. Le agradezco a Hernán Duarte y a María José Yglesias la coordinación del evento, a cada uno de los panelistas su generosa participación, a Arbitration la donación de libros a la biblioteca de nuestra universidad, a los media partners la difusión, a los asistentes al evento. Gracias por sumarse esta mañana y por sus ganas de aprender y por querer poner su grano de arena para crear un mundo mejor para todos. Muchas gracias.
Gracias, Aurelia. So for our first panel, I introduce Herman Duarte. He will be moderating today's webinar.
Thank you so much, María José. But the first panel will be moderated by Santiago, Zuleta, and by Karima, Sauma, and Annette Magnusson. That's our first panel that will be talking about climate change and arbitration. Karima, as a lot of people know here, is director of the Arbitration Center of the American Chamber of Commerce. She is a well-known international arbitrator practitioner. She used to work at COMEX. She used to work also at an important law firm in New York, and has been in this place for a while, and also works as counsel with DJ Arbitraje in exclusively international arbitration cases. And Annette Magnusson is a global international arbitration practitioner. We know Annette Magnusson for having had the pleasure and opportunity to have her visit Costa Rica and El Salvador and have the very first human rights and arbitration event in Central America. I think it was also in Latin America. Karima was also part of this event. And it's so great to see the really innovative practice she's founded with Andrina that is going to be in the next panel on climate change counsel. So lawyers dedicated completely in aspects of climate change. Annette, as everyone saw, even she grabs audience from around the world, like honorable former ambassador from Spain to Sweden that is joining in this conference. We welcome him as well. And Annette was the director of, just like Karima now is the director of an arbitration center. Annette was the director of the Arbitration Center of the Stockholm Chamber of Commerce, which is one of the main venues of the world for resolving disputes. So, and I can keep going and going and going and going, but better talk with the interest in Annette and Karima, please.
Thank you, Herman. And I'd like first to say thank you so much to ULACIT and Herman for organizing this. It's wonderful to be here. It's wonderful to see so many faces interested in climate change, human rights, and arbitration. For me, it's wonderful when we can speak of the virtues of arbitration and how we can help this world to be a better place. And climate change, which is one of the most pressing topics that we have right now, is a great way to start and to think about how arbitration can make this a better place. I'm not going to introduce Annette Magnusson because Herman did a wonderful job of introducing her. Annette, it's so great to see you. As Herman mentioned, it was great to have you in Costa Rica. We hope we can have you here again in the future. For now, let's talk a bit about climate change and arbitration. First, to have context, how can international arbitration be relevant for climate change disputes? Because sometimes we think that this doesn't make sense, or that arbitration wasn't made for these types of disputes. So how do you see this connection between the two?
Thank you, Karima. And let me also start by thanking Herman, ULACIT, and all the other organizers of this webinar, and for the invitation to address you and to be part of this conversation. It's a true privilege. And as Herman alluded to, I had the privilege to visit Costa Rica a few years ago, and it really holds a very special place. The trip and the meetings we had there, and the seminar we organized at that time, and also a few months earlier that winter in El Salvador, very, very special. And now I have the fortune to be able to move into a new role, and devoting 100% of my time to climate change issues, and in particular sort of bridging the gap between climate change law and the realities of climate change, and for example on the corporate side. So this is what we will be doing going forward at Climate Change Council in different capacities. And so to your question, Karima, so how can international arbitration be relevant for climate change, and what is sort of the connection there between the two? I think there could be, the answer to that question could be twofold. We could talk about substantive issues, and we could talk about the procedural issues. And looking first into sort of the substantive issues, so what is it when we talk about climate change disputes? And one way of looking at that is to see what do we know about climate change law and policy, and how is that relevant to international arbitration. And I think what we need to keep in mind is that whatever happens in the disputes in international arbitration on a daily level is really a mere reflection of what is happening in the world around us, and in the world in which international arbitration operates. And that has always been true, and this is something we will see also going forward. And the commercial reality of climate change is that we need to see a very large societal transition. And this, with this, we will see a large increase of investments. That this is what we need to see happening, and to some extent we already are seeing this. Because the private sector is becoming more and more involved, and that involvement needs to increase in the transition efforts. So you could say that the private sector is mobilizing, but we also know that more is needed from the private sector when it comes to climate change mitigation and adaptation measures. There are many numbers about this from different reports and different organizations that have studied this intensely. And so one example, of course, just to mention one, is a report earlier this spring from the International Renewable Energy Agency, IRENA, where they note that the investments for energy transition needs to arrive at more than $130 trillion between now and 2050 to reach the targets. And of course, that's a huge number. And energy transition is not the only societal transition we will see going forward. So we will have construction, infrastructure at large, transport sector. There could be issues of water and sanitation, and the list could go on, where we need to see the private sector getting engaged in societal transition. So there is really an urgent need for scaling up the business activities, you could say. But in parallel to this, or an awareness that should be brought into this conversation as well, is that not enough is already happening. So there needs to be an increase of the efforts. And I think a very telling description of what needs to happen going forward was delivered at President Biden's Leaders Summit on Climate in April, where we could hear the executive director of the International Energy Agency tell the heads of state that, and this is a quote, that IEA analysis shows that about half of the reductions to get to net zero emissions in 2050 will need to come from technologies that are not yet ready for market. So half of the reductions. So what this means is that we need to have massive leaps in innovation, and we also have to have innovations and tryouts and new technologies. And I think this trend, where as we see innovations across the board when it comes to energy, when it comes to hydrogen, for example, there could be synthetic fuels, carbon capture, and other technologies. This will be visible in the arbitration case laws, because we do know that if you have a set number of commercial transactions, so to speak, you will have a small portion of that unfortunately will end up in disputes. That's sort of just the realities of doing business. This we know from before. So again, whatever happens in the commercial world will be reflected in international arbitration cases. So just to summarize the substantive issues in the interconnection between climate change and arbitration, is that new technology and new policy and many new actors that could also be experienced, combined with the speed with which this needs to happen, this altogether will probably constitute what could be called a complicated cocktail and result in disputes. And arbitration practitioners will see the result of this in the cases going forward. And if you look at international investment arbitration, we have seen in the past, and that's something that we could keep our eyes out for also for the future, that where there is instability of policies in different jurisdictions, and there has been examples of that in the past, as we know, this could also result in disputes and also relating to investments relevant for climate change mitigation and adaptation purposes. So there is a strong interconnection, and I think this interconnection will continue going forward. So then one could ask, well, is there any difference if you use international arbitration in a climate change related context? Or is it just like any other sort of specialized area of dispute resolution when it comes to international arbitration? And I do think the answer to that is probably both. So of course, the general advantages of international arbitration that we all are very familiar with, the ability to engage expertise for that particular issue that is the target during the case, is available. You have the flexibility, you have the speed, and I think the speed issue will be perhaps even more important at the point in time that we are in right now, given that we do not have much time before the gap is closing to reach the 1.5 degree targets under the Paris Agreement. We need to work fast, and therefore, whatever disputes occur, whenever lessons can be learned from these disputes, that needs to be resolved faster than perhaps even faster than before. So I think, yes, arbitration, because of its inherent qualities and inherent advantages, is particularly suitable to address some of these disputes that we will see probably in the future. And that is something to keep in mind. But another thing that one could ask of, in addition to the strength of international arbitration, and also perhaps in picking the expertise when it comes to these types of disputes, one could ask the question if the arbitration procedure as such is something that we should discuss specifically. So I don't know if I want to stop there, Karima, if you have any follow-up questions, or if we should continue.
That is so interesting, and I completely agree that arbitration reflects what is going on in the real world, so to say. And arbitration, and I think one of the great advantages is that it's very adaptable. And we've seen it with the pandemic and how arbitration has been able to rise to the occasion and help resolve disputes while we're all away and apart from each other, and with physical restrictions and other types of restrictions, and just keep solving problems that are pressing and that are important to solve. And so I would like to know more about what that you're saying about the procedure and how it can help with these types of disputes.
Sure. And before we go into the procedure, perhaps I should also take this opportunity to mention that there have been surveys in the past on sort of how present climate change related issues is already in international arbitration caseload. So in Stockholm, we did a survey that was published in 2019, where we looked at, and when I say we, I should say it's not me, it's Andrina, who is also on this call, who was then working and supporting the SSC with this survey, which was published in 2019, looking at green technology disputes, both in commercial and in investor-state arbitration cases at the SSC during 3 years' time. And that survey revealed that we can see a fair number of disputes in general commercial agreements that are closely related to climate change mitigation targets. And it's interesting to note this, and I think it will be interesting going forward to see additional reports like this from Stockholm, but also other institutions, to see how we actually are already resolving climate change related disputes in international arbitration. But if we look then at the procedure and sort of how could the arbitration procedure be adopted, or should it be adopted in a way to meet the particular needs of climate change related disputes. And I think there might be room here for arbitration to make even more contributions to the joint efforts to fight climate change. And that is the way we view confidentiality in international commercial arbitration. Of course, in investment arbitration, much is already quite open and transparent. But if you look at commercial arbitration, that, of course, is not the case. And that is one of the main attractions for many corporates and many parties to use international arbitration to begin with. And that should be safeguarded. That should not be changed. However, though, I wonder if we could not do more when it comes to sharing experiences learned during the arbitration process to the benefit of more than the parties involved in that actual dispute. And what I mean by this is just referring back to the statement from the IEA director stating that half of the reductions needs to come from technologies that are not yet commercialized, not yet perhaps even in the market. They are being innovated. They are being tried out as we speak. Now we know, of course, that will come with challenges and experiences gained before they are perhaps fully operational or commercialized in a way that works. In a different time where we did not have to worry about the time limit given how much the emissions have already increased globally, had we not had to worry about that, then of course we could go on as usual. But since we need to work so fast, and since we need to learn from one another faster than we might have had earlier, we need to reduction targets are as early as 2030. And that's just not taken out of thin air. That's taken because science tells us that's necessary. So why not try to figure out a way to, in these new innovative techniques, when or if or when they bump into bumps in the road and there is a dispute, what the parties learn regarding policy, regarding technology, regarding commercialization, regarding issues that could be deemed as sort of generic from that dispute, why not try to find a way to share that outside of that immediate disputes? So climate change dispute related business intelligence or something like that. If we could find a way to do that, I think that could be for the greater benefit of all. So that could be one very concrete way of adopting the arbitration procedure when there is a climate change related issue involved in the actual dispute. Again, it would have to be done in a way where the confidentiality of the parties and their specifics is respected. But where there are generic issues that could be of relevance for all to learn, why not try to share it? And one could even take the view, we all remember how the inventor Röntgen shared his invention and never even applied for a patent because it should be benefit for mankind. And although it could be difficult, of course, to apply that mindset if you are a party, a portion of that could be applied and pull out some of the details. Again, that could be benefit for the collective to help us speed up the process in the societal transition. So that would be one concrete proposal from my end, that we should try to have a slightly different view on confidentiality, even in commercial arbitration, where there are climate change issues involved.
That's very interesting, because I was going to say precisely that in commercial arbitration, parties are much more interested in the confidentiality aspect of the process and I guess it will be a real challenge to see how much they want to open up and how much they want to share about their process, because we're at a point where even publishing awards is subject to controversy. So it would be, I mean, I'm very interested in seeing how this plays out, but I'm wondering if we go to the investment arbitration sphere and think about the transparency efforts that have been going on for quite a few years, and how this is something that's interesting for constituents and for people to know more about what's going on in investment arbitration, public policies in place and stuff like that. I'm wondering how much of this climate change intersecting with arbitration you've seen in treaty negotiations. So how much states have shared about their interest in including aspects of climate change in their treaty negotiations, and if it's something that's happening or not happening, or how do you see this interplay could help with better provisions to promote climate change action?
I think if we look at the modern model treaties from governments, for example, the Netherlands model BIT is many times mentioned as an example of where you actually very much see in the model BIT the presence of and the awareness of climate change issues, and even the mentioning of the Paris Agreement. So I do hope that we will have that more visible in future treaty negotiation. And although I have not been sitting myself in the treaty negotiations, I would not be surprised if that was the case. And there might be other people on this call that have a more sort of have been in the room when these treaties have been negotiated. But my impression is certainly that this is getting high up on the agenda and higher than before. And hopefully we will see language that helps us make the climate change ambitions into something that is more than ambitions. It actually can be interpreted as an obligation in the end. So the actions that needs to be taken by the parties, both in a commercial context, but also in a public international law context, that you would have the aspirations moving into the sphere of obligations. Certainly you have seen some examples from climate change litigation decisions where you could argue that this is actually what has happened given the decision by the court. Not every litigation of case relating to climate change has this result, but there has been some that one could argue that would be an example of where climate change has now moved from being a policy ambition to being translated into a legal obligation under international law. But I do hope that we will see more ambitious model BITs referring to not only climate change, but sort of the general SDG ambitions going forward.
Exactly, and I think the older treaties that have environmental carve-outs and that have corporate social responsibility obligations do help in that regard, and help states regulate in environmental aspects, and is in line with the climate change action pursuits. If we go back to arbitral institutions, do you think arbitral institutions could or should collaborate and coordinate more in optimizing climate change related arbitrations?
I think it's always very good if arbitral institutions collaborate, and we both, I think, know from experience that that is something that happens in practice, that there is much to be gained from institutions jointly working to make international arbitration to deliver at the highest level possible across the globe. And when it comes to climate change related issues, I think, for example, finding the correct expertise for a particular case where you have climate change elements involved is a very good area where institutions could reach out informally to each other and just try to find the most suitable person. I know at the SEC that could happen in cases where there was a particular need for particular expertise, and we just wanted to sort of expand the pool or the knowledge internally to find the correct candidates. And there we could reach out to colleagues at other institutions to find that. And I do think that given that climate change related issues might be potentially in some respects a fairly new field, that could be why it will be so relevant to learn from each other in finding the best person to sit in the case. So that could be one area. And then I think when it comes to the idea of sort of the transparency or the sharing of know-how of climate change related substantive issues that could be relevant for someone or parties outside of the immediate case, that also is a potential area where the institutions could work together and potentially develop some sort of a protocol in if that were to happen, what would be the issues that you would be looking for and how would you report it? And if that would be done in a coherent manner, that would, in my mind, increase the value of that type of information.
I completely agree that things work better when we collaborate. And I think the pandemic has been a great opportunity for institutions, since we have everything virtually, and then we sort of found out that we can meet without having to fly to other countries. And for the past year, I was involved in so many meetings with other heads of arbitral institutions talking about how to collaborate in different aspects. And I think climate change is one of those where we haven't exploited that resource as much as we could. For example, in Costa Rica, there's no government body. Well, there is a government body that authorizes and oversees arbitral institutions, but it doesn't have a budget to promote arbitration and to promote anything that has to do with alternative dispute resolution. So arbitral centers have been at the center of promoting everything that has to do with arbitration at an academic level and just in general. And I think that this is an area where we could work as well together to have more information, promote education, and how arbitration can be a wonderful tool to help with climate change related disputes and promote the protection of the environment and other public policy goals. I think it's just a matter of finding how we can go about it. And besides the great examples that you just posed, if we could find a way to generate a common agenda or and thinking, I don't know, different and creative ways of letting people know that this is happening and this is an available tool. Because I think most of the time what happens with arbitration, and or at least in Latin America, is that people don't know or are not aware of the possibilities. And I think that's the barrier that we have now today with climate change and arbitration. It's something that at the beginning people are wondering, how is this going to work? How does this make sense? And part of the role of institutions can be to make this more evident, show how this works and how this is something that makes sense for arbitral institutions and other actors in arbitration to get involved in. And I'm wondering, Annette, because you have so much experience as being the Secretary General of the SEC, of the Arbitration Institute of the SEC, and also now in your role as Climate Change Counsel, are there any cases that are interesting that you could share with us? Of course, preserving confidentiality and such, but something so that our audience can picture how this works in real time. And
Well, thank you. I think when it comes to sort of understanding what we mean by climate change related disputes in international commercial arbitration, I would encourage you to take a look at the report that I mentioned, Green Technology Disputes in Stockholm, because really what you get there is a showcase of the different disputes that we could sort of put under the umbrella of climate change related. So, and I think it's important to keep in mind that climate change is not only disputes under sort of the Paris Agreement, right? And I think we have made this clear here during this conversation you and I have had. But it sometimes you could the mind could be led in that direction, thinking when we talk about climate change disputes, that's what we mean. But really, climate change again could be present in so many ways in a commercial dispute, even though just indirectly. But the substantive issues are important for climate change mitigation and adaptation purposes. And I cannot enough underscore how this level of innovation and the size of the investments we need going forward, how important that is, and how the private sector needs to step up and to some extent already is stepping up. We have seen a lot of green technology and sort of climate change related disputes in investor state arbitration. And thanks to rules on transparency and sort of routines for transparency, much of this is in the public domain, and much of it, of course, is related to renewable energy and investments in renewable energy. And I think regardless of the substantive outcomes of these cases that have already been decided, I think one takeaway, taking a step back and just looking at this, is just to see the importance of policy, the importance of energy transition policy. And I do think here it is important to widen the conversation and to learn from these cases and these experiences into a discussion on energy transition policy at large, and into the rules where energy transition policy is being decided. So again, regardless of the outcome of the cases, I think there are lessons to be learned in both scenarios. So I think from a transition policy perspective, the investor state arbitration cases relating to renewable energy are very interesting.
Yes, definitely. And we've seen how Spain and other actors have been involved in various cases, and that's very interesting. I actually read the report that you're mentioning, and I found it fascinating. I think we could send it to our audience once this is over, because it's a very complete report and illustrates very well what we're talking about here. So congratulations on that report, because it's really, really well done. At this point, I want to see if there are any questions from our audience. No, see, there's been a lot of action in the chat, but
and I see Herman has posted a link to the report as well in the chat, so there you can find it.
Perfect.
And of course, we have Andrina speaking after me, so who's the author of the report. So she can take questions relating to that, I'm sure, as well, in addition to her human rights intervention.
Perfect. So
I have a question. Just a short question, a very quick question, Annette. So what exactly does Climate Change Council will be doing? Like with what sort of companies will approach you? Like, hey, Annette, give me some consulting on climate change. How can I cut off my carbon emissions? How is this going to work? Because we saw recently in May a decision in Holland against Shell Corporation, right? That it was ordered to reduce the carbon emissions. And another question, a second question, considering since you're from Sweden, have you spoke with the famous climate change activist Greta? Are you doing any events with Greta? If not, I think it would be a great team, no, to work together with her.
Thank you, Herman. Yes, it would be great to have an opportunity to discuss directly with Greta. Unfortunately, I think the line is very, very long to speak with Greta. But of course, if that would be an opportunity, we would grab it immediately. She's a great voice for action, for sure. So on your first question, what Climate Change Council will be targeting and referring to, for example, the case you just mentioned from the Netherlands, I think one conclusion that one could draw from that is that if you are a corporate and you have sort of an ambition, an ambitious agenda internally when it comes to living up to the standards under the different instruments mentioned by the court in that decision, you need to ask yourself, how would we have fared in that analysis that the court submitted Shell to in that case? So that could be a very concrete question that a company could ask themselves, and where we would be helping them making that assessment. So that's a concrete answer to your question. But in general, at Climate Change Council, our ambition has always been to use the law as an accelerator for climate change action. So that is by, for example, studying the law, making studies. We are currently now involved in a fairly large study to see how the ECT is actually functioning in relation to energy transition policies, and whether the way ECT is functioning in practice, if that is supporting or hindering or none of the above climate change efforts or the energy transition. So that's a concrete study that's an example of what we will be doing. Training is an important issue, and working with the corporates and working with professionals at corporations where doing sustainability issues, they might not necessarily be lawyers involved in that. So understanding the Paris Agreement, understanding the international instruments. And again, I think that the recent decision from the Netherlands illustrates the importance of understanding the content of these instruments and their implications for your practice, and how you conduct yourself and how you communicate how you can conduct yourself. So that's another concrete example. So it's really quite wide. You know, we call ourselves consultants, where we can make a difference, where we can use our experience within the law, within international disputes, within research, human rights, to be that accelerator, to be the product manager, to be the researcher in support of climate change efforts. That's where we want to be.
And Annette, we have a final question from our audience. They say, how do state courts fare in terms of dealing with climate change disputes?
So we have seen in recent years a substantial increase when it comes to climate change litigation, and that is usually against governments, that the governments are not doing enough, or government agencies, but there are also a fair number of cases against private companies. And the decision we saw from the Netherlands, as far as I know, this is the first case against a private corporation which has been successful in a state court. It's a first instance decision, and as I understand it, the company will file an appeal. So we have not seen the final decision there, obviously, yet. And state courts, they arrive, I mean, obviously these cases are being brought under different legal instruments, depending on the national law, depending on the constitutional possibilities in that jurisdiction. But, and courts arrive at different sides of the fence, if you want to call it that, supporting or not supporting the plaintiffs in these cases. But I do think what is interesting is that it appears to be a growing consensus among the courts that are seeing these cases that climate change is an issue, that it is a problem, and that it is caused by human activity, and that so they understand the concern from the plaintiffs. And many times the plaintiffs are young people. It's teenagers coming together in NGOs or in other forms and filing these claims because it's their future, right? So even in cases where the government or where the courts have not found to the advantage of the plaintiffs, there could be important language in the reasoning of the court that has, to some extent, been what could be called good news in sort of affirming and acknowledging the existence of climate change problems. And we might take that for granted now, but that's not always been the case, and it's not certainly the case everywhere and with everyone. So I think that's sort of a secondary, but perhaps equally important role by the state court decisions.
Thank you, Annette. And with that, we've run out of time. Thank you so much, Annette. This was very enlightening, and I'm sure we all have a lot to think about and a lot to discuss after this. And with that, I hand it over to the next panel.
Perfect. Thank you so much. There is more questions. I'll send, you can check on the question and answer panel, Annette. Perhaps you can write back to Miss Elvira Fernandez that wrote one more question, but there's no more time. So now we ask, please, Andrina and Santiago to open your cameras. Andrina, as Annette has introduced us, works as a co-founder in Climate Change Council and was before also at the SEC, has extensive experience in aspects of climate change, human rights, and it's so wonderful to have her here in Costa Rica virtually. And Santiago Zuleta works in one of the, I would say, one of the most iconic law firms in Latin America, Zuleta Abogados. If you see the logo of Zuleta Abogados, very interesting, the way it's traced, the C, I really like it. Santiago used to work also at the Supreme Court of Colombia, a court that has suffered with blood, that has blood on it. We cannot forget the historical moments that this court suffered during the 80s, the narco period of Colombia, that justices and people there were killed by the guerrillas. So Santiago, I guess these are things that have molded him into become a human rights expert. And I'm very happy to introduce them for this human rights and arbitration panel that they will be discussing. So Santiago and Andrina, welcome.
Thank you very much, Herman. Good morning, good afternoon to everyone, depending on which part of the world you are. Thanks to Herman for the kind words and Simple Legal Consulting and the organizers for this initiative to open a space and speak about innovative trends in arbitration, and for the invitation to share some ideas with this magnificent group of professionals. Before introducing Andrina, we'd like to make a small preamble on the topic we are going to talk about today. We have been witness of social unrest and political violence around the world. People around the world is demanding access to fundamental rights. The pandemic has shown the dark side of capitalism and democracy. Latin America, for example, is suffering the consequences of weak institutions, unstable economies, and populism. Unemployment is high, health systems is poor, and access to education is very limited. This crisis has raised questions on the effectiveness of international institutions. So this is a good opportunity to think and talk on the relationship between international trade, investment law, and human rights, among others. Does international trade contribute to inequality and breaching human rights in poor countries? Should states renegotiate their BITs and include human rights clauses? Is arbitration an effective mechanism to solve disputes involving human rights? To explore some of these trends, I would like to introduce you our main speaker for this panel, Andrina Kjellgren. Sorry if I misspelled your last name, Andrina. Andrina is a lawyer with a significant experience in international development and project management. Most recently, she worked with the World Health Organization in Indonesia, advising on the integration of human rights perspective in various health programs and managing various collaboration with the United Nations systems. As the Stockholm Chamber of Commerce in 2014 to 2019, she conducted research on the interplay between international law and environmental protection and managed several large conferences and publications. Andrina is the Chief Operating Officer of Swedish nonprofit IT for Children, where she mainstreams sustainability, human rights, and gender equality in the organization's activities in Ghana. Welcome, Andrina. The floor is yours.
Well, thank you so much, Santiago, and also Herman for that kind introduction. Thank you, everyone, and ULACIT for inviting me to speak today. I'm very excited. This is the first time I'm speaking specifically for an audience from this region. So I hope I can deliver something useful for your work or for your study. I've prepared just a few slides, so I'd like to share my screen. Yeah. Can you see it now? Yeah, okay, great. So today I'm supposed to talk about human rights and arbitration, but I do want to talk a little bit about the substantive part of human rights and not going directly into the procedural aspect of enforcing that human rights. So I'd like to talk about specifically a right that has gained a lot of attention and becoming more and more important today. In the time that we're living in right now, which is the time of climate change, as Annette has mentioned, also biodiversity loss. So I'd like to talk specifically and start by talking about the right to a healthy environment. So the right to a healthy environment, or usually in its full name, the right to a healthy, safe, clean, and sustainable environment, is a precondition to other fundamental human rights, because you can imagine without a healthy environment that it would be very difficult to realize the right to life, or the right to health, or the right to property, right? And the right of a healthy environment is already adopted in 155 countries, so it's almost a universal acceptance in countries' constitutions and also national legislations. Well, the UN has not formally recognized the right to a healthy environment in a human rights convention, but in 2018, they published the framework principles on human rights and the environment. So these framework principles are quite important. It consists of 16 principles. So it establishes not only states have the obligations to protect the environment and to prevent environmental degradation, but also it provides obligation to states to provide environmental education for citizens, to provide information on environmental condition, and even to safeguard the rights of citizens to assembly in environmental matters, for example, to establish environmental organizations. And all of these are very important today, especially in the fight against climate change. So this framework is not binding, but it's supposed to inspire national legislations or activities by countries. So I do invite you to check in your national legislations if you do have recognized the right to a healthy environment and what that entails in your jurisdiction. And because I'm very excited to talk in this region, I started to do research a little bit about what's happening in the Americas context. So I found this very good news from 2020. So for the first time, the Inter-American Court of Human Rights recognized the right to a healthy environment in a landmark decision, Indigenous Communities member of the LACA-HONHAT Association versus Argentina. I hope I got that right. So the case was about the indigenous community. So they claim that other communities and the state itself have promoted illegal logging activities in the area where they live. And because of this activity, it has reduced forest resources and also affected biodiversity, which in the end affected their ability to seek food and water in the traditional way that they usually do. So they brought a claim first into the commission, and then it went on to the court. And the court ruled for the first time that Argentina had violated so many rights, but for the first time, the right to a healthy environment, because Argentina did not do effective measures to stop these harmful activities for this indigenous community. So here we can see that the court, in this case, as courts all over the world, as Annette mentioned before, be it international courts or national courts, they have to start to acknowledge the importance of environmental protection and climate change also for protection of human rights. So that's about the right to a healthy environment. Oh, sorry. Okay. And then now I'd like to talk about the trend. So the right to a healthy environment is a substantive right? It still needs to be enforced. And this is where arbitration could come into play. So I'd like to discuss some trends in human rights and arbitration. And these trends perhaps not specifically related to the right to a healthy environment, but I think it's important for us to look at it because it might be relevant for future cases. So there are two specific trends that I'd like to talk about today. So first is the publication of the Hague Rules on Business and Human Rights Arbitration. That was quite recent in 2019. And the second is a trend very specific to investment treaty arbitration or investor-state dispute settlement, which is human rights counterclaim. So as the background behind these Hague Rules is that more and more states are requiring businesses to start respecting human rights. So if we take one example, say in France, so French law now requires a company of certain size to make a plan how to safeguard human rights in their operations. And the EU might soon make human rights due diligence mandatory for companies. And also at the international level, as we know, in 2011, the United Nations issued the UN Guiding Principles on Business and Human Rights. And then one of the provisions in these guiding principles is that states should provide access to effective remedies for those who are harmed by business activities. And this is exactly the background of the Hague Rules. So the Hague Rules on Business and Human Rights, it aimed to address the perceived remedy gap in the UN Guiding Principles because states might not be able to provide this remedy. So perhaps the parties that are impacted by the human rights violation can seek the remedy themselves using international arbitration. So the Hague Rules, there is basically ancestral arbitration rules from 2013. So I believe that the business world and the arbitration community they're already familiar with these rules. There are, however, some adaptation. For example, they integrate the ancestral rules of transparency, making the hearing public. There would be publication of documents, and then also tribunals should allow for third-party participation. And also, if you look at a possible impact on a business activity to human rights, it might impact a big community, or it might have a very wide impact, so that these rules also anticipate the possibility of multi-party claims. So how are we going to use these rules? So the rules could be used in contracts between businesses or with stakeholders, particularly actually in supply chain contracts, where complex supply chain might actually pose a risk of human rights violation. And another possibility is that multiple parties may enter into multilateral agreements. They provide for business and human rights arbitration if they work in a sector that has quite high risk of human rights violation. So one example I can mention is the Accord on Fire and Building Safety in Bangladesh. So this is a multilateral agreement between a number of multinational companies and a number of trade unions following the collapse of garment factory in Dhaka in Bangladesh in 2013, if you remember that. So following this, this incident, actually there were two arbitrations arising from this accord. It was commenced by trade unions against two fashion brands. The case was administered by the Permanent Court of Arbitration in The Hague. So both cases were actually ultimately settled in 2018, but this case I think represents a significant example how business and human rights arbitration can be used for resolution of human rights disputes. And finally, because the Hague Rules on Business and Human Rights Arbitration is arbitration rules, so we might expect also the advantages, as Annette had mentioned before, as Karima had mentioned before also. We might expect speedy process, that parties will be able to pick the expertise from the arbitrators that they think is suitable for the case. And then they also can make sure that they select or appoint the arbitrators that are completely neutral. I have to say that we are yet to see an arbitration using these rules. Maybe it already exists, but again, going back to the point that actually Karima mentioned, we don't always know what's happening inside the Arbitration Institute. But we may expect that these rules can also be used to arbitrate violation of the right to a healthy environment. And I would like to see that. And then Now let's look at the new trend, or maybe it's not very new, from 2017 in international arbitration, specifically in investment treaty arbitration. Just a little bit to give a context, maybe most of you already understand this, but investment treaty arbitration or investor-state dispute resolution is a method to solve disputes under international investment treaty. So foreign investor can bring a claim against host state where the investment takes place for an alleged breach of investment protection under the treaty. So traditionally, in the investment treaty arbitration sphere, the claimant is always foreign investor, and then the respondent is always the host state where the investment takes place. However, in this case, Herbacer versus Argentina, this is the first known case where the host state actually brought a counterclaim against the investor, claiming that the investor has violated human rights in doing its business activity. So let me just walk through the case a little bit because it's quite interesting. So the investor in this case was, they're shareholders of a concessionaire in that provides water services in the province of Buenos Aires in Argentina. So the claim was brought under Spain and Argentina bilateral investment treaty. So the claim in this case is that the investor claimed that Argentina had disrupted their operation and also refused to renegotiate the concession, which in the end led to a significant financial loss of the concessionaire, and in the end led them to file for insolvency. And I would not focus so much on the claim of the investor, but I'd like to talk a little bit about the counterclaim by Argentina. So the Argentina launched a counterclaim saying that the concessionaire, they did not provide sufficient level of investment in this supply services, which in the end led to violation of the human rights to water, which I think is very interesting. So how did the tribunal decide on this? So first, on the jurisdiction, the tribunal viewed that Spain-Argentina bilateral investment treaty actually has a broad jurisdictional clause. It only says that the tribunal has jurisdiction for any dispute related to the investment. So according to the tribunal, then it's not only about a claim from the investor against the host state, but it can also cover a counterclaim from the host state against the investor. And then the tribunal on the merits went on to say that corporations actually can be subject of international law. And they also say that the right to water is an internationally recognized human rights. But, and this is what I think where things get tricky, the tribunal actually said that they cannot apply specifically that the investor has the obligation to provide, to make sure the human rights to water realization, because the tribunal was in the view that to be able to do that, because this is a positive obligation, means that you have to give this human right for the investor to have that obligation. It should be included in, even if not in this particular treaty, but in other investment treaties and or in general principles of international law, which didn't exist according to the tribunal. So even though there's this counterclaim, so in the end, this counterclaim failed. But I think it still shows an interesting trend, because now imagine if the treaty text will be supportive of human rights, if the treaty text would actually say that both the investor and the host state have the obligation to respect human rights, maybe Argentina will actually win in this case. Which brought me to my final point about the connection, a possible connection between investment treaty arbitration and the right to a healthy environment. And I think there are two sides of the coin. So first is that on the impact of investment activities. So investment activities might cause environmental degradation, right? It might pollute water, air, soil, for example. And it's not only actually on foreign investment activities, all kinds of investment activities. It can also be investment by the state, for example. But in terms of foreign investment activities that cause environmental degradation, and then there's a case against the host state for something else. So how states could include this in their arguments in the investment treaty arbitration or in a counterclaim. I think this is an interesting area to explore. But then on the other hand, investment activities can also promote environmental protection. For example, as Annette had mentioned before, by bringing in new technology that is very necessary as part of transition to net zero or as a part of climate change mitigation. So how do the investors also make an argument about this in the investment treaty arbitration? That's also an area that's quite interesting to explore. The second side of the coin is that states, they might want to regulate for environmental protection, and this very type of measure might directly impact foreign investment. So a classic example is if a government wants to ban a certain chemical because it's dangerous for water sources or it's dangerous for the air, for example. But these measures can directly impact a foreign investment. For example, if the investor sells this chemical or they produce this chemical, right? And then the investor might bring a claim under investment agreement for this. So you see, there's a need to balance the two. And I think there are efforts that's been going on to balance these two with the new drafting of the new investment agreements. So the new bilateral investment agreements have introduced environmental protection clause, which obliges states to maintain a particular level of environmental protection. And that also host states should not lower their environmental standards to induce or to promote investments or trade. And some new bilateral investment treaty texts have also included provisions that the investor should respect human rights. So some of these treaties are South African model BIT, Netherlands model BIT, Morocco, Nigeria, BIT. And that brings me to my conclusion. So again, human rights, health, environment is very important today, and it's acknowledged in the legal systems of the majority of countries. And business activities might violate human rights, and the Hague rules may provide suitable procedural rules to provide remedies for those who are harmed, but we are yet to see the use. And also, finally, it's very important to have a progressive investment treaty text that acknowledges environmental obligation and also human rights obligation for it for the states to have a stronger standing later on if there is a dispute. So I guess that's it from me. Thank you very much. I'll stop sharing now.
Thank you, Andrina, for this powerful presentation. Before opening the mix for a question from the audience, I would like to ask a question to you regarding the last trends that you just mentioned. There's evidence from the panels that just show of a change in the emphasis of modern international investment agreement regarding environment and human rights. States may seek to impose human rights duties and obligations on corporations as a condition of protection under investment treaties. To establish its own levels of domestic labor, or for example, an environmental protection, and to adopt or modify its relevant laws and policies, will have an effect on investors' behaviors and specifically on their legitimate expectations. Can you tell us a little bit about that trend and that effect?
Yeah, thank you so much, Santiago. As I mentioned a little bit, so some of the new treaty texts have included the environmental and human rights obligation. But there is also bilateral investment treaty that includes, they call it the denial of benefits clause, right? So basically some parts of the benefits in an investment treaty does not apply anymore to the investor if, for example, they violate human rights. And we see this in Morocco and Nigeria, BIT. So I think this might also be popular in the modernization process of the other bilateral investment treaties.
Thank you. Thank you, Andrina. Yes, I have one question here in the chat, and it's the following. What are the implications of data protection law and the competing considerations of privacy as a human right in contemporary commercial arbitration?
Wow, that's a very big question. To be very honest, I'm not familiar at all with data protection law, but I could imagine that it infringes, human rights to privacy. Depends on which human rights treaty you are referring to, or if you actually do have it in your national legislation. If you look at some of the cases in investment treaty arbitration, for a lot of the cases where the argument is successful is when the particular things at issue is actually already regulated in the national legislation. So I think it depends on what your national legislation would regulate. Yeah, I don't think I can say more than that.
Thank you. I'm not an expert either on that topic, so I'm not sure if my opinion or my answer would be correct. I think that's all for the panel. Herman, I don't know if you have any other questions or any other person in the audience. If that is not the case, I will give you the floor, Herman, again. And thank you very much, Andrina, for your intervention.
Thank you so much, Santiago. Thanks so much.
It's a pleasure.
Thanks.
Thank you very much. So if we move forward for the next conversation, I would like to ask Manuel Echeverria, please, and Dr. Garrido to turn off the camera so we can introduce you. Welcome, Dr. Bourne. Welcome, Manuel. I'm very excited that the two of you are here. Manuel, and I have the privilege to work with Manuel. He's such a great person, and I always say he's the Costa Rica's best kept secret in procedural law and arbitration law. So it only made sense for me to invite Manuel to speak with the leading author of international arbitration in the world that we're so happy to have here, Dr. Bourne. His credentials are quite extensive, but I will only say something that I found really fascinating from a recent interview that is going to be published in Líder Legal, which is one of our media sponsors that we have, that he said, what would be an advice? So I'm introducing the person that says this. What would be an advice for people out there, how to accomplish things and to take every opportunity as your last opportunity? And that really resonated with me and vibrated with me. So I take this as a big opportunity. We're going to present this book that is heading to ULACIT libraries alongside 6 other books that already are in ULACIT. 3 of them, we're waiting others from Holland, from another sponsor, Walter Kluwer, that generously sent these books. So without any more delays, I give the words to Manuel and to Dr. Garrido, who are presenting this very interesting book, 6th edition, first one from 1999, and now from the year 2021. So welcome. Mute.
Good morning. Thank you very much, Herman, for your introduction, your undeserving kind words, almost false advertisement. Thank you very much for the organizers and the sponsors of this event, and especially for the privilege and opportunity to be able to chat with Mr. Bourne, and especially thank him for giving us a time of his busy agenda. Dr. Bourne, it's a great pleasure to meet you.
It's my pleasure entirely, and thank you for the opportunity to speak today, and of course thanks to all the many attendees for having taken time out of their valuable time out of their day.
Thank you very much. As Herman was saying, the main purpose of this panel is to introduce one of your many works. And writing is such a generous entrepreneurship, because at the end of the day, you are sharing your knowledge, even with your counterparts. So I'm always curious to ask, especially when it's someone as a practitioner as you writes, what did motivate you to write this book 20 years ago? What interests you in the subject?
That's an excellent observation and also question. I forget exactly who said it, but I always recall the quotation that when you write a book, it's a gift to your enemies. And that's, I think, especially true when you write a legal book. We have at my law firm a rule that unless we absolutely have to, we never cite one of my books as supporting authority. Yet I don't think there are any cases when the opposing party doesn't break that rule, doesn't cite me against us. And in that sense, both this book, but also the other books that I've written are very generous gifts to my enemies. Fortunately, we usually don't take positions that are incorrect, so it isn't of much help to my enemies. But nonetheless, one always has to remember that quotation. The reason for having written this book, but also other books about international arbitration, international law, as well as some other subjects, was I think what we all want to do as lawyers is to make the world a more orderly, in a sense, better regulated, better governed, in some other sense, freer place. And one way we do that is through our professional activities as lawyers. We fight, quite literally, for the rule of law. If we're sitting as arbitrators, we make, in some sense, the rule of law. And we do that in individual cases, which is, in some sense, like looking through a keyhole. It's a very narrow focus, very intense focus on one specific case, but it ultimately involves only the parties to that case, even if they're big, important parties or countries. When you write something, you affect the rule of law. You advance the rule of law in a different way, perhaps less direct. You're only commenting on what the law should be. Perhaps people listen to you, perhaps they don't. But you can at least speak in a broader sense than just through a keyhole, just affecting one or two parties. You speak about the law itself generally. And if you're lucky, only if you're lucky, then someone actually picks up what you've written and reads it. And perhaps some court somewhere, some legislature somewhere actually thinks what you say or part of what you say might make a little bit of sense and follows it, perhaps only in part, but nonetheless follows it. And in that way, you can accomplish, albeit in a different way, the very reasons that you became a lawyer. All of that was true for me. That's why I wrote this book, but also other books. And
it's been a long time since the first edition was published, more than 20 years. Now it's your 6th edition. Can you tell us, especially from your position, that obviously it's one very unique because you're an academic, you're an arbitrator, you're a lawyer. How does the trends or the subject of which you wrote about almost 20 years ago have changed and evolved during this lapse of time?
The book is titled International Arbitration and Forum Selection Agreements, Drafting and Enforcing. It's much different than my treatise, International Commercial Arbitration, or my book on international arbitration law and practice. This book, Drafting and Enforcing International Arbitration Agreements and Forum Selection Clauses, is much more of what I would call a primer or recipe book in a sense. It's directed not at theory, not at abstract reasoning, not at the policies that underlie different aspects of international law or of international arbitration law. Instead, it's a very practical, pragmatic book that is aimed at assisting practitioners, also in-house counsel, in the nitty-gritty, nuts and bolts drafting of dispute resolution provisions. It discusses with many concrete examples how to draft an arbitration agreement, how to draft a choice of court agreement, how to draft a choice of law provision. And in each case, as I mentioned, giving examples, both in particular of what to do, what kind of model clauses one might use, but also what not to do, what kinds of mistakes sometimes get made, and really it's better to avoid. Interestingly, over the last, I guess, 22 years since the first edition, many things have not changed. Some quite important things have changed. Things like emergency arbitration, expedited procedure, consolidation, joinder. Some issues with respect to the law governing the arbitration agreement have also changed. But if you compare the 1999 to the 2021 versions, you'll also see many overlaps. A lot of things haven't changed. Basic advice, I always call the basic advice for drafting an arbitration clause KISS, for keep it simple, stupid. The theory that if you try to be too clever and at the outset before any dispute has arisen, you will very likely tie yourself in knots when some dispute that you didn't really think about turns out to be the one that you use the arbitration clause for. And so that basic principle, KISS, coupled with using institutional model clauses, the model clauses that the Singapore International Arbitration Center, the ICC, other leading institutions recommend, is the basic advice that existed back in 1999 and continues to be the basic advice today.
Thank you. As you were rightly saying, your book gives like a detail on how to go about when you're drafting and writing these clauses. Can we focus just a little bit on the big don'ts, on the big no's? Still, you as an arbitrator, what kind of issues do you still see on the drafting as a problem of clauses that might come up on a litigation?
It's funny, right? Our arbitration clauses on one level are not so complicated. The classic arbitration clause, and I just say this off the top of my head, could read, all disputes relating to this contract shall be finally resolved by arbitration conducted pursuant to the Singapore International Arbitration Center arbitration rules. That's all you need to say. It's not very complicated, and one would think, especially given that arbitration clauses tend not to be of commercial interests to businesses, one would think that most parties would get a clause like that or countless other variations of that same basic sentence correct, that they wouldn't somehow make a mistake. If you look in the treatises, if you look in the arbitration case books, if you look in the law reports of most countries, though, you'll see countless examples of so-called pathological clauses, clauses that depart from that basic formula, clauses also that depart from the recommended model provisions of arbitral institutions, instead essentially try to reinvent the wheel. And they make mistakes about almost every aspect of that provision. They make mistakes, for example, with respect to the scope of the clause. Sometimes they won't define the scope, or sometimes they will define it extremely narrowly, all disputes arising under Article 12 of this contract, or perhaps a little bit more broadly, all disputes arising out of this contract, which many courts will interpret to only include contractual claims. But they make mistakes with respect to the scope of the clause. They make mistakes with respect to whether arbitration is mandatory or alternatively just an option to be considered, but which needs subsequently, after a dispute arises, to be reconfirmed before either side is bound to arbitrate. They make mistakes about choice of an institution. Many clauses, I'm sure we've all seen this in practice, I've seen it many, many times, refer to an institution that either never existed, the International Arbitration Association, or the International Arbitration Center, neither one of which, so far as I know, actually exists. Or an institution which used to exist, but which doesn't exist anymore. For example, the old East German Arbitration Association. They make mistakes with respect to the relationship between arbitration and litigation. For example, a clause says all disputes shall be resolved by arbitration and by litigation, or two provisions, an arbitration clause followed by a choice of court clause, each one independently contradictory of the other. And a countless litany of other similar mistakes. They're all sometimes called pathological clauses, and it's very easy to avoid them just using a model institutional arbitration clause. I've written an article about so-called pathological clauses where I try to say that we shouldn't view these pathological clauses as sort of diseased monsters who should be forgotten and whose effect is nothing at all. They shouldn't be regarded as null and void. Instead, we should view them with care and generosity and a little bit of pity. We should seek to remedy them because after all, they do reflect the party's predominant object, their underlying fundamental purpose of resolving their disputes by arbitration. And so what courts should do is not invalidate these pathological clauses, but instead help them to recuperate, to heal them.
And on that last point, how do you go about with the remedy? How do you achieve that as the arbitrator?
That's a great question. And there are two basic choices to be made. Let's take one of the examples that I gave. For example, you have a clause that provides all disputes relating to this contract shall be finally resolved by arbitration in accordance with the rules of the International Arbitration Center. The seat of the arbitration shall be Singapore. Now, there is no International Arbitration Center. There are two ways that you could remedy that defective clause. What you shouldn't do, what neither of these remedies does, is say, well, the parties agreed to something that's impossible. They agreed to arbitrate under an institution's rules, which doesn't exist. And so since what they agreed to is impossible, you invalidate the entire arbitration agreement. You should not do that. That's the wrong approach. Instead, you should take one of two approaches. Approach number one, you blue pencil or red pencil or green pencil, rainbow pencil, the reference to the International Arbitration Center out of the clause. What are you left with? You're left with an ad hoc arbitration agreement to arbitrate seated in Singapore. Perfectly valid arbitration agreement. Singapore International Arbitration Act provides default rules with respect to selection of an arbitral tribunal and all the other procedural aspects of an arbitration consistent with the UNCITRAL model law. Perfectly sensible approach. Second approach, and I promised that there were two remedial approaches. Second approach, you say what the parties intended to do here was to have an institutional arbitration seated in Singapore. What do we think they likely meant when they talked about International Arbitration Center? The most likely thing that these parties meant, but inaccurately expressed, was the Singapore International Arbitration Center. They thought that just by saying International Arbitration Center, seated in Singapore, that was enough, but in fact, they used the wrong name. they're lay parties. They didn't know any better. We will therefore give effect to what they must have intended, namely an SIC arbitration seated in Singapore. I can't speak for the SIC, and in all cases, I'm the president, but I'm not here today in that capacity. But I suspect in many cases, the institution and also Singaporean courts would see their way clear to one of those two approaches, and in particular the latter.
Thank you very much for the clarification. The book that we're presenting is called International Arbitration and Foreign Selection Agreements, Drafting and Enforcement. For us that might not be so familiar with the subject, what relationship there is between, because we're more familiar to talk about an arbitration clause or arbitration agreement, what relationship there is between a foreign selection clause and an arbitration agreement? How do they overlap in some way?
It's a very important question. And they overlap and are quite similar in a number of respects. In each case, two commercial parties that have concluded or are about to conclude a contract decide that they want enhanced predictability, regularity, perhaps expertise and neutrality in dispute resolution if in the future, unfortunately, disputes arise. They have two ways of doing that. They can either agree to international arbitration in a particular way, particular institution, particular arbitral seat, in which they consent to the authority of the arbitral tribunal to finally resolve their disputes. The arbitration requires their consent. It is a purely consensual process, and by agreeing to arbitrate, they consent to arbitration as a means of dispute resolution. A choice of court clause has similar motivations in the sense that the parties they don't want to have multiple litigations in different countries, different national courts. They want the predictability of litigation in one particular court, or in the case of a non-exclusive forum selection clause, at least the possibility of litigation in one specified court. They do it for the same reasons: predictability, hopefully expertise of the court that they choose, or at least convenience.
Neutrality. Okay. And sorry if I focus a little bit on this subject, but having you and us being here in Costa Rica, I wanted for you to talk a little bit of the importance of the seat of the arbitration when drafting the arbitration clause. What is the effects? And then I would like to ask some more local questions to see how internationally are we seen?
Sure. So the seat of the arbitration, as we know, is fundamentally important. In choosing the seat of the arbitration, you don't really pick the geographical location for hearings. Hearings can be held under almost all arbitration agreements, all arbitration laws, anywhere in the world. You instead make a choice of law decision. You choose the arbitration law, also the national courts of the particular jurisdiction that you select to govern your arbitration, to govern things like the arbitral procedure, the qualifications, independence and impartiality of the arbitrators, the right to counsel, obligations of counsel, opportunity to be heard, all of the procedural aspects of the arbitration. Also, very importantly, you choose what courts have the authority to annul or set aside the arbitral award. Of course, there's only one set of courts, the courts in the arbitral seat, that can do that. And so by choosing the arbitral seat, you pick this very important legal framework. You choose, for example, Costa Rica as your arbitral seat, then it's Costa Rican national arbitration law that applies to the procedural aspects of the arbitration, Costa Rican courts that could annul or set aside the award.
Thank you. And obviously, we would love to become a seat for international arbitration, to be considered as a place where you can put into the provision on the arbitration clause as a seat. So in your experience, more than these factors, theoretically speaking, when the parties are deciding which is going to be the seat of the arbitration, how does that come about in practice? Not like I understand that the principles that everyone's looking for, but how can you implant something like the Inception movie? This idea like, oh, Costa Rica could be a place to take care of this arbitration.
So almost always parties go into negotiations about dispute resolution desiring in the first instance either their own home courts or alternatively their own home jurisdiction as the arbitral seat. They think, rightly or wrongly, that may give them some advantage in the future. So you have party A from Albania and party B from Belarus. Party A wants Albania as either the choice of court or alternatively the arbitral seat. Party B wants the same thing except Belarus. Both parties soon realize they're not going to get what they want, and they therefore fall back on, as their second choice, a neutral but also expert, experienced, efficient arbitral seat. Sometimes they might choose a national court, but for a number of reasons that we needn't go into just at the moment, national courts are decidedly inferior to arbitral tribunals with respect to resolving international commercial disputes. And so parties typically will end up saying, we will choose a neutral arbitral seat with good expertise, good experience in international arbitration. And in that category, they look at a number of specific factors. They don't always look at them in a hugely sophisticated way. I think they look at it sometimes very impressionistically, sort of what they've heard the last time they looked in the newspapers or talked to an arbitration partner or flipped through some book like the 6th edition of my book. What they look for is first, a legal framework that is favorable to arbitration and that lets arbitration work efficiently, expeditiously, even-handedly. That typically means something like the UNCITRAL model law. They also look for a judiciary that is maximally independent and free of accusations of some sort of corruption. And importantly, that has a track record with international arbitration cases, disputes. They want the confidence that the local courts will treat the award the way that the UNCITRAL model law envisage. They also look for an experienced community of local arbitrators. In many cases, not all by any means, but in many cases, the presiding arbitrator, sometimes all the arbitrators, come from the arbitral seat. And so you don't want to choose a seat where there's nobody who really knows much about arbitration. Costa Rica does not have that problem, so it's in a good place with respect to that. They want also to choose a place which they think is relatively stable, where there's not going to be some dramatic change in government policy or where there's a concern about external political influence. You might think of some places in Asia at the moment that have that sort of issue. And instead, a place where they can be secure that the legal framework that they pick and the courts that they pick are likely to stay more or less the same and more or less independent for the indefinite future. Those are the principal considerations. Sometimes, and you can never exclude these possibilities, sometimes people look at things like convenience. What if we have to have in-person hearings in the arbitral seat? How easy is it to get to New Zealand or Canada, Vancouver? How easy is it to get to Costa Rica? They will look at those sorts of considerations. But the primary focus is and should be on the first set of categories that I mentioned.
And from your expertise, which countries do you feel that in Latin America are taking the right directions to become a relevant seat for arbitration, or who has gained a more terrain during the past years?
Yeah. So, I mean, it's very interesting, I think, how Latin America has developed. It's developed, I think, a little bit differently than many other places. Let me give you what I think is the European paradigm. In Europe, typically, smaller, more neutral jurisdictions have flourished. And by that, I mean, Germany, Russia haven't really done all that well. They're not well known as arbitral seats. And that's notwithstanding the fact that they've got the UNCITRAL model law, both Germany and Russia. In contrast, smaller jurisdictions, Switzerland, the Netherlands, Sweden to an extent, Austria to an extent, have done well. I think that is in part because of the neutrality of those jurisdictions. It's exactly because Switzerland isn't an economic powerhouse in the way that Germany is that it has done well, and I think the same could be true of the other ones that I mentioned. At the same time, England, London specifically, France, Paris specifically, have also done quite well as arbitral seats. And I think that is in part because of the deeply international character of both London and Paris, which has enabled them to, together with, for example, international commercial and financial communities in those two places, attract a number of parties. Also, the existence of a strong local arbitral institution, the ICC in the case of Paris, the LCIA in the case of London. In Asia, that overall trend is even clearer. The two preeminent arbitral seats are Singapore and, at least in the past, Hong Kong, both relatively small, surrounded by very large economies, India, China, to a lesser extent, Indonesia, Malaysia, Taiwan, Vietnam, Philippines. And yet it is the two small neutral jurisdictions, Singapore and previously Hong Kong, that were quite effective, indeed preeminent in international arbitrations. I mention all of that because I think it's directly relevant to Costa Rica. Historically, in Latin America, I think the country that has done best is Brazil, which is a little counterintuitive and a little different from the other two European and Asian examples that I give. Brazil has, I think, attracted substantial amounts of arbitration, mostly Brazilian-related arbitrations. I mean, certainly you can have arbitrations from elsewhere seated in Sao Paulo or wherever, but I think Brazil has really focused on Brazilian-related arbitrations. There's also the language issue between Brazil and much of the rest of Latin America. I think, though, that the historic trend in other parts of the world suggests that Costa Rica ought to have, well, does have the potential for a very vibrant international arbitration community, future in dispute resolution. It's neutral. It has a strong legal community. It won't have many conflicts in the sense that an India or a China might have. And I therefore think if you look at experience elsewhere, it has a lot of potential. Now, potential by itself doesn't produce success. One really has to work to make something of that potential. Singapore didn't get where it is by waiting for people to come. It worked really hard to develop both a pro-arbitration judiciary, a legislative framework, a legal community that was attuned to international arbitration, and ultimately it succeeded. It takes long-term effort. This is not a short-term endeavor.
Can you expand just a little bit more, and especially with all your knowledge of Singapore, on how they precisely did that?
Sure. So Singapore did it first by adopting in a very deliberate way the UNCITRAL model law, and then by periodically updating the model law to take into account recent developments, for example, with respect to emergency arbitration and emergency arbitrator awards. Second, Singapore ensured that its judiciary was experienced in international arbitration. The current Chief Justice in Singapore was a former international arbitration practitioner, and both all aspects of the Singaporean government, all branches of the Singaporean government made it a deliberate policy to facilitate international arbitration because they thought that advanced the rule of international law, which is a fundamental part of Singapore's foreign policy and its national DNA. They created and supported an arbitral institution. The Singapore International Arbitration Center was founded in the beginning of the 1990s. Became over the last 30 years a world-class international arbitral institution. They attracted non-Singaporean practitioners to participate very actively in both SIC, the arbitral institution, but also in international arbitration generally. That can be a politically sensitive issue because by attracting foreigners, you at least arguably disadvantage locals. But Singapore took a very long-term and I think very, very wise decision that you would attract international arbitrations and also provide a better quality of international arbitration through the very diversity of involving foreigners together with local practitioners. Took a very long-term view, which I think has paid off. And the early presidents, chairmen of the Singapore International Arbitration Center were from outside Singapore. Michael Pryles was the founding president of the Singapore International Arbitration Center Court of Arbitration. He's not Singaporean, he's Australian, and he did a spectacular job in getting the institution on its feet. I think it's very interesting when you compare Singapore to other jurisdictions which have done extremely well in international arbitration. Which ones do I mean? I mean, in particular, London, where I am, and where historically a number of non-English international arbitration practitioners were located. I think of people like Julian Liu, others in the international arbitration field here in London. The same thing is true in Paris, where although the leading international arbitration practitioner for some time was the late Emmanuel Gaillard, who tragically, unfortunately, has passed away, there have always been a number of non-French practitioners doing international arbitration in Paris. I think of Chris Seppala at White & Case. I think of many other practitioners in Paris who, although they adapted themselves to the French international arbitration world, integrated into the environment, were originally from elsewhere. That's also certainly true in Hong Kong as well as in Singapore. It's even true in New York and Miami. And so I think one very important step is to make sure that one's sort of local international arbitration community actually has within it important representatives from other places. That gives, because international arbitration ultimately is about parties from different countries, that gives parties from different countries comfort that somebody understands quite literally their language, but that somebody also has a sense of their expectations and their needs.
So we have a lot of work ahead. I know that Herman has also a question, and I have also a question from Mrs. Dyalá Jimenez. So because we're running a little bit short of time, I'm gonna give the floor to Herman, and maybe he can also pose Mrs. Jimenez a question. So we can all take advantage of this great privilege of talking with Mr. Bourne.
Thank you so much, Manuel. It has been great to hear you and hear Dr. Bourne. Connecting with these previous conversations and your book, I would like to ask, because we have a young audience as well, students from this vibrant university, ULACIT, that hopefully we will see you also giving some classes with these wonderful students, where Karima Sauma, that was before, also teaches, and María José Yglesias, the dean of the School of Law, is here as well. And I know that you were involved long time ago when you were an associate, a mortal human being in a Greenpeace case. And I have a question on if you could tell us a little bit about the case where you got involved, represented the interest of Greenpeace. Because if people over here can Google a little bit of Dr. Bourne, you will see that he has represented all sort of people, clients that are big corporations, states, Greenpeace, NGOs, even national rebel forces, right? It's like very diverse set of clients, so interesting. And the question connecting with your book, since you're talking about how to draft agreements on how to solve disputes, is like, how do you sit down with the state and pretty much tell them, you're gonna solve this dispute through arbitration and I'm gonna sue you, so after this. So this is a very interesting aspect for me.
That's a great question. It goes back in time just a little bit. It was my first arbitration, and I recall when, as a young associate, one didn't feel quite mortal. One felt, in a sense, already dead as a young associate. I was called into the office of the senior partner in the firm, and he told me, and I'd actually seen it in the newspapers that day, that Greenpeace, an environmental protest group, had a vessel mysteriously sabotaged, blown up, sunk in Auckland Harbor in New Zealand. Nobody knew who had perpetrated this bombing, but that the president of Greenpeace had called him up, and his assumption was that this must have been the work of the CIA. Nobody else was stupid enough to have done something like blowing up Greenpeace's boat in a peaceful harbor. And he therefore went to a Washington law firm, which was what my law firm at the time was. And we were supposed to figure out how we could sue the CIA. It soon turned out that actually the CIA didn't do this. It was instead, tragically, the French equivalent thereof, the French intelligence service, who were angry with Greenpeace because the protest vessel had been sailing into restricted waters around the island of Mururoa in French Polynesia, with the object of preventing, obstructing nuclear tests. And to prevent that obstruction, which was costing millions of dollars, the French intelligence agents blew up the Rainbow Warrior. Ultimately, they got caught. Local New Zealand police turned out to be highly efficient, and they caught the secret agents who had done this thing. And at that point, our mandate as lawyers changed. It wasn't any longer to catch the CIA. Instead, it was to figure out how to sue France. And the way, going exactly to your question, Herman, the way that we persuaded France to agree to arbitrate was to threaten to litigate. And I think a little bit like most businesses, France took a very pragmatic view. Perhaps we don't like arbitration so much, but one thing we do know, we like arbitration more than we like litigation. We dislike litigation even more than other types of dispute resolution. And so rather than facing a lawsuit in New Zealand, in the United Kingdom, somewhere else, France, or perhaps lots of lawsuits in different places, France, just like many businesses, decided quite pragmatically, in my view, quite sensibly, to resolve the disputes by arbitration. It's a little odd in a sense because it involved a dispute that had already arisen. Most arbitration clauses are negotiated before you have a dispute, but you certainly can have so-called compromis, submission agreements where you take a dispute which has already arisen and submit it to arbitration. And this gave France certainty about the forum. We agreed to arbitration quite near to France, right across the border in French-speaking Switzerland. So I think they felt some comfort from that. I think they hoped that there would not be the threat of jury trials or runaway verdicts in some national court that they didn't have any voice in. Ultimately, the arbitration went forward, notwithstanding the unusual subject matter and the unusual parties, just the way most arbitrations do, entirely collegial and sensible means of dispute resolution. A little unsurprisingly, given what I've said, there was an award made against the French Republic, which it promptly paid for some $6 million US, which back in the day, mid-1980s, was actually real money. And Greenpeace was able to replace the Rainbow Warrior with Rainbow Warrior 2.
Wow, amazing, Dr. Borna. And moving on to another question before we open the questions for the audience. So people in the audience, if they want to have opportunity to ask something, now is the time. This comes from Dyalá Jimenez Figueres, that is going to do the closing of the event. She's an arbitration practitioner, has her solo practice in arbitration, first established in Chile, now back in Costa Rica after a successful time as Minister of International Commerce, that she led the path to Costa Rica to the OECD, which I think is a very interesting factor that adds another jewel to the Switzerland of Central America, as Costa Rica is usually called. And a small commercial of Costa Rica, now that there is a big corruption scandal going on. It's interesting to see how the rule of law works in this country, since you will never see in Nicaragua or El Salvador, where I am from, the General Attorney Office doing some investigations inside the presidential house, which is happening now. It's sad that it's happening, but it's also good to see the rule of law working. But Dyalá, I already did her pre-introduction, sorry about that. Asked this question: in Enca versus Chop, the English Supreme Court decided that the applicable law to the arbitration clause was the law of the contract instead of the law of the seat. First, if you're familiar with this case, which perhaps you are, what do you think of this decision? And then it says, could it be a step away from the thesis of a transnational arbitration law or the uniformity sought by the New York Convention? And then if I connect this question as well with your campaign on Clue Arbitration blog against the Hague Convention on that you've been writing about. You have this Hague Convention of Choice of Law, which I think is kind of connected with this last part of the idea of uniformity through New York Convention and how this other convention actually affects the principles of the New York Convention.
So thanks so much. Dyalá is a good friend, and she did a great job as in the government, unsurprisingly. So I am quite familiar with Enca versus Chubb. The majority cited my treatise on a couple points, but notwithstanding the assistance that I tried to provide, I think that with respect to Dyalá's question, the Supreme Court, the UK Supreme Court, actually made a mistake and reached the wrong result. Notwithstanding that, there's another aspect of the decision which I think makes their mistake a little bit less damaging, not entirely free of harm, but nonetheless less damaging. And let me touch on those two related points. First, it's absolutely correct. The court held that in principle, a choice of law clause in the main commercial contract will apply to and select the law governing the related arbitration agreement associated with, or which is part of the main contract. I think that's the wrong conclusion. I think choice of law clauses ought to be interpreted as applying to the commercial terms of the underlying commercial contract and not to the separable arbitration agreement. I think that absent a specific choice of law clause in the arbitration agreement, that arbitration agreement should be governed by the law of the arbitral seat. I think the law of the arbitral seat has a much closer connection to that agreement, the agreement to arbitrate, than does the substantive law in the underlying contract. I think that a host of practical difficulties arise from subjecting the arbitration agreement to the law governing the underlying contract. If you think of things like everything from confidentiality to consolidation to the arbitral tribunal's obligations of independence and impartiality to the power to award interim relief, I think all of these questions must be governed by the law of the arbitral seat, and yet heavily influenced by the terms of the parties' arbitration agreement. It makes no sense to have the parties' arbitration agreement governed by a different law on all these and on other issues than the law of the arbitral seat. And so I think the Supreme Court made a quite fundamental mistake in AMCHA versus Chubb. The second point, though, very quickly that I wanted to make is that they ameliorated that mistake somewhat by also adopting the validation, what I call the validation principle, namely, if application of the law of the underlying contract would invalidate the arbitration agreement, then you won't apply that law. Instead, you'll apply the law of the arbitral seat. That validation principle is longstanding. It's codified, if I can put it that way, specifically in the Swiss law and private international law, but it's also reflected in very old common law decisions going back well more than a century. There's a delightful case that if you like legal curiosities, the case of Hamlin versus Talisker Distillery, the same Talisker that makes whiskey that you can buy in duty-free stores these days, involved application of the validation principle to uphold an arbitration agreement on the theory that you're not going to apply a law that would invalidate the arbitration agreement, which the parties went to so much difficulty drafting. That would amount to just throwing it away as so much waste paper, the House of Lords at the time said. And by adopting the validation principle, I think the court took a little bit of the sting out of its mistake on choice of law.
Thank you so much, Dr. Bourne. María José Yglesias, the Dean of the School of Law of ULACIT, has a question too.
Yes, thank you, Dr. Bourne, and thank you, Herman and Manuel, for the wonderful moderation. So as a closing question, both to Dr. Bourne and for Mrs. Jimenez for her closing statements as well, what would you say to students and to person beginning their legal career about the opportunities and challenges in arbitration? What can they look ahead to? What do you think they should get started with? And what should be their aim and focus if they're interested in this particular area of practice?
Well, thank you, Dean. Maybe I'll take a first crack at that, and then Dyalá can express her own views. I think international arbitration offers students in every country opportunities that don't exist in a number of other practice areas to work abroad, to work with people from other jurisdictions, to ultimately live and move abroad if that's what they wish to do. Arbitration, as my presence on this discussion suggests, is uniquely international, and thus and if you look at the arbitration practices at any of 3 or 4 dozen international law firms, you'll see people from all over the world, including Costa Rica, Central America, elsewhere. There are therefore many quite important opportunities. That said, I don't want to overpromise in a sense or create false enthusiasm. Because so many people do want to do international things, it's highly competitive. People from many different jurisdictions, many people from larger jurisdictions are quite keen to be in international arbitration practices, and thus it's challenging to find the right fit, the right place for yourself. And one has to be both determined and tenacious, but also recognize that in some cases there may ultimately not be an opportunity. I can say that if one is fortunate, lucky in my case, to find a place, it can be in international arbitration. It can be enormously fulfilling, enormously satisfying. And so I would encourage people to think hard about it, but not necessarily to assume that it is going to be an available opportunity.
Hi, I don't know. Greetings, everyone. Hello, Gary. It's so wonderful to see you. And I'm sorry, I was very shy in the beginning because I thought I would wait for you to introduce me and for my closing. It's great to have this opportunity and have Gary and Annette and everyone with us in Costa Rica in a way. And I think this whole discussion has been particularly important for Costa Rica because as Herman was saying, we are strong in rule of law and we're strong in the fight for climate change. So I want to congratulate the organizers, Herman especially, and of course, María José and ULACIT, but also the speakers. I guess if I may, maybe I'll just begin by answering María José's question as to what I think people can do, young students can do. And I agree with Gary, this is a highly competitive arena where 20 years ago or more when I started, if you were, you were lucky to have an opportunity, your CV didn't need to be as complete as it is now in terms of the profile. But I do think that one of the characteristics of arbitration is the high standards. So I would suggest people who seriously want to take it as a career to seek internships or jobs, if possible, at law firms. Global law firms provide a horrible way of good training. As Gary said, he was feeling dead when he was an associate, and I know what he means. I actually started with, the late Manuel Gallard, so I'm very lucky. And also institutions, be they academic or arbitration centers, provide a good opportunity. So aim high and try to get the highest standards in the start of your career. For closing, let me divide my closing in two. The first, I wanted to run by what was discussed. And the second part, I want to just add to the questions that have been asked, my own questions. And I want to start by Aurelia Garrido saying that we're all here para crear un mundo mejor para todos, to create a better world, or as Gary said, to make the world a freer place. And I think that's quite inspiring. And sometimes, ordinary people who are not involved in arbitration have a difficulty in seeing that we're actually good people trying to make the world a better place. And this particular event really is aiming at that. Annette in the morning was explaining the strong interconnection between arbitration and climate change and how arbitration can contribute. And her idea is, one of the ways that it could contribute even more, especially in the area of commercial arbitration, is by sharing knowledge that is learned or taken from the cases to fight against climate change and to help speed up the process in the energy transition. And with that, she meant maybe having a different view of confidentiality, where in investment disputes, we have already reached a higher level of evolution. Although I actually would add that even in commercial cases, in some institutions like the ICC are moving towards less confidentiality requirements. Andrina then talked about and described the Hague Rules on Business and Human Rights Arbitration, which is a novel instrument that was very interesting. And then she went on to also describe the first case where there was a counterclaim brought by a state for alleged violations to human right to water, which is Urbacer against Argentina. And of course, while this case and others have shown to offer a forum for such remedies by states, I wonder myself whether the passive role of states under the current, at least, model of BITs, is something that is a reality, and maybe other fora could be a better use for that fight against violations to human rights or to environment. And then Gary Bourne opened speaking of his generous gift to his enemies and how through his publications he hopes to contribute to the development of rule of law, because it allows him to speak to a broader audience. And I think it's interesting that the most important piece of advice came in the form of a kiss, which is interesting. And he addressed pathological clauses by calling for an attempt to remedy them instead of doing away with them. And I think that's important. He also responded to Manuel's questions regarding what good seats of arbitration look like. And I'm very happy that he emphasized how Singapore updated the UNCITRAL model law. It's one of my personal obsessions. I think we need to update the UNCITRAL model law in many ways. And I want to ask Gary in front of everybody if I may quote him on his views on ENCA v. Chubb, because I'm writing a sort of homage to Emmanuel Gaillard, because I think I agree with part of the things that he was saying. So, and now to really close on what I want to add to this discussion is just to emphasize a lot of what Annette was saying in the morning. Challenges that we're facing, we have numerous. On the one hand, we have the changes in technology, which are very speedy, and we have pressure from the growing demands of civil society driven by the urgency of the effects of climate change. But on the other hand, we have a relatively slow and irregular, especially, process of changes in policies and legal regimes, and coupled with the interest of participants in the old model, in the old energy model. So we have this dilemma, these two worlds, and how can arbitration contribute? Well, there again, I want to echo Annette's words, the importance of policy. I think that policy is the key, because arbitration is an adjective. I mean, no matter how important we know it is, and no matter how much we update the tools surrounding arbitration, it is still, in a way, the adjective. So, and I want to give an example. If we in Costa Rica have a wonderful decarbonization plan, but we don't lay out the specific policies and the specific rules, including the incentives to make it happen, there is only so much material that arbitrators can deal with or can take from in this resolution of the disputes. So we need to, I'm not sure arbitration can be better as an adjective than the substantive, if you will, aspect. So we do need to connect them. And the question is, how do we participate as an arbitration community in that conversation? Because I think one of the wonderful things that our community has is that it's quite dynamic. We're self-regulated in a way, and that allows us for some flexibility and even speed in how we're updating our own regulations. And I think we as a community, in a very large extent, including the investors, including the judges, we could contribute to build the fight or the conversation around climate change with certain coherence, which I think would be ideal. So, you know, the two main questions I have is, are we including everyone in this conversation? Because the process is as important as the result, and it's also in a way driving the result. And the second question is, are we using data when we have this conversation? And in that sense, I'm referring especially to the criticism surrounding investor-state dispute settlement and how sometimes the lack of data can drive the conversation in one direction and, you know, and make the whole system weaker instead of stronger. So to end, I think we also have another frontier beyond climate change is related to our livelihood, the pandemics and our health issues. That's another whole big area where I think we are going to need to have conversations. So thank you, and congratulations again to everyone, including, of course, the moderators who did a wonderful job.
Thank you, Dyalá, and thank you to all the speakers for your valuable time, to all the partner organizations that helped make this possible, to Herman and Simple Legal Consulting, not only for the organization, but for the wonderful moderation that they always do in these high-level events that are really an added value for all of our students. So we hope everyone enjoyed, and please find in ULACIT your second home for these wonderful conversations. Have a great day.
Thank you.
Thank you so much. Bye-bye.
Thank you very much. Ciao.
Gracias.
Bye,
Adiós.
gracias.
Gracias.
Felicidades.
Hasta luego, hasta luego. Gracias a la señora ex ministra.
Gracias,
No
Herman.
la podemos presentar, pero la presenté en una pregunta, así como...
Sí, mejor. Gracias.
Yo diría que fue la conferencia con el smoothest closing transition in the history of Zoom Talks. No, sí, a mí me gustó mucho.
No sé si smoothest,
Súper
pero
corto.
Muchas gracias.
Fue to the point. Igual todos saben quién es usted acá, Dyalá.
Gracias. Y gracias, María José. Felicidades a los dos. Excelente. Gracias.
Sí, muchas gracias a usted.
Dyalá, y gracias,
Chao.
Herman.
María José le voy a llamar.